Hi, everybody. My name is Catherine Del Rosario with McEntee Law Group. This is our first Fridays, so every month someone from our team will hop on here and answer any of your immigration questions. We'll go through some immigration news updates, and we like to do this every month so that you have a chance to get your pressing questions answered. As always, this is meant to be general information, not legal advice. Everybody's case and situation truly is unique, so you'll definitely want to talk to an immigration attorney or an accredited representative about your specific situation. So I see some people are joining in on our live. Just know that you can ask your questions in the chat or in the comments, and I'll be happy to address them. Hi, everyone. Okay, so we'll start with some news updates. As a lot of people may already know, the H-1B cap lottery window has closed. And so if you want to confirm whether you were selected or not, your employer and your attorney would have been notified, but they can log into their USCIS account just to confirm and pull that selection notice. I haven't gotten a chance to see what the statistics look like this year, like how many people entered the cap and how many total were selected. But I can say, from our team's experience, we did notice an increase in the number of selections. I would say about maybe a third of our registrants were selected, but this is the first round. There can always be a second and sometimes a third round. And with that being said, if you were selected, now your attorney and your employer have about 90 days. Well, they have 90 days to file your H-1B case. And if it's approved, then you would switch to H-1B status come October 1st of this year. If you were not selected and you want to consider what your alternative options are, I would reach out to our team or another immigration attorney to explore what possibilities there might be. Just generally speaking, day one CPT could be an option. If you are someone of extraordinary ability, you could consider the O visa. If you're looking longer term, your employer could start the green card process for you, but we need to also consider what your short-term options are. And you could also think about working remote from your home country or somewhere else in the meantime, if you're not able to find an alternative status. So definitely contact our team to talk about what your options could be. Next, we wanted to confirm that USCIS fee increases are definitely now in effect. So USCIS updated many of its fees, and a lot of them have significantly increased. So if you're wondering whether the old fee applies to your case or the new fee, USCIS will look at the postmark date of a case to determine if the correct version of the forms were used and if the correct fees were used. Now, I think it's important to note that if you had a filing deadline, however, like if you needed to get your case filed by a certain date, USCIS will look instead at the date received. So not at the postmark date, but the date received by USCIS. Good news for medical exams. So when you are applying for a green card or an immigrant visa, you are required to obtain a sealed medical exam from a civil surgeon to make sure that you're not ineligible for the green card for health-related reasons. And USCIS released a new policy that says that if a medical exam that was signed and completed properly by a civil surgeon on or after November 1st of 2023, if that was completed, then the medical exam won't expire. It can still be used as evidence that someone is not ineligible or inadmissible under these health-related grounds, um, it can be used as evidence indefinitely. So that's great news because the concern used to be that, we didn't want our clients to get their medical exams done too soon out of fear that they might expire, but now that won't be an issue. Okay, the next item I wanted to cover is that there's another new USCIS policy that for those applicants who are pursuing citizenship. So if you're filing the N-400 application for US citizenship, there is now an option to choose a third gender. So historically, it was, binary system, binary options, male or female. And now there is a third option, another gender identities, which will be marked with an X. So this will allow you to choose that third option if that's right for you. And USCIS has confirmed that the once the case is approved and you get that document confirming that you have citizenship, that that new gender selection will be printed on that document. And the last item I wanted to mention is that new US citizens will now be able to seamlessly request updates to their Social Security card. So starting April 1st, citizenship applicants will have the option to request an original or replacement Social Security number card and update their immigration status with the Social Security Administration without having to visit the SSA in person. So for example, if you obtained a Social Security number when you were here on a different status, like you were a student or in some other, working visa, and it has that, typically there's a notation on there that says, only valid for work authorization. When you become a citizen, you don't need that notation. And I know it can kind of be an obstacle when pursuing certain types of employment, like federal employment. So under this new rule, if you're applying for citizenship, you can request that updated card that won't have that notation, same number. And so that's a great convenience and great move towards efficiency. Okay. I see questions coming through and I will definitely address those. We received some questions ahead of time, so I'm going to go through those first. These were great questions. So the first one is about H-1Bs. So can a CAP exempt employer file a CAP subject petition? I guess my first question when I hear that is why? Why would a CAP exempt employer want to do that? There's a huge benefit to being able to qualify as a CAP exempt employer, the biggest one being that you're not required to enter your potential employees in the lottery. You can hire and petition H-1B workers any time of the year if you meet the requirements. So I guess I'm curious what the thinking behind that would be. The other thought I have is that there are certain questions on the H-1B application that employers have to answer related to whether they're CAP exempt or not. And so as with all of these forms and all the questions on the forms, you have to be truthful. So I'm concerned that if you were to answer one way about an employer on one case, but then answer a different way, that it could either compromise like a past petition or future H-1B petitions. So I think generally if an employer does qualify as CAP exempt, you'd want to stick with that status unless there's been some kind of, significant change. One other question is, can I petition for a green card for my child if they are over 18 years old? So important definitions and wording is super important in immigration, and the definition of a child in the eyes of immigration has a specific meaning. So under the immigration statute, a child is an unmarried child under 21 years old. So, you know, from the perspective of the parent, it matters what the status of the parent is and how old their son or daughter is. So, an unmarried child under 21, if the parent is a US citizen, is considered an immediate relative. And that means that a visa, an immigrant visa, is always immediately available to that child. That means that they can file their green card application or their immigrant visa without having to wait in line for that green card. They still have to wait for the case to be processed, but a visa is theoretically, available to them at any time. Green card holders can also petition their children, so their sons or daughters that are under 21. US citizens and green card holders can petition their unmarried sons or daughters who are over 21. And then only US citizens can petition their married sons or daughters who are over 21. And the wait time for that immigrant visa or that green card will depend on your relationship, whether the child is married or not, their age. So their category is very important. And then the country that they're from. So there's a lot of things to consider in this question. But it is possible depending on the age and the status of the parent. There's another question that's related to H-1Bs. Can I work a side hustle on my H-1B visa? No, you cannot. So the H-1B visa is specific to the employer, the job, and the location that was laid out in your H-1B case. So any work outside of that, side hustles, would be considered unauthorized employment. And you want to stay away from that. It could compromise your future options for a visa or for a green card. This next question is related to marriage-based green cards. So the question is, we've only been married for 1 month. Do we have to wait a full year before we start the green card process? No, but you still might want to consider the timing of things. So theoretically, as soon as a couple is legally married, they can start the green card process. But keep in mind that the government is looking at the big question that they're trying to answer is, is this couple the real deal? The legal term that we use is this a bona fide marriage? So did this couple intend at the time that they were married to spend their lives together? And there's not one thing that they look at, it's the whole picture. So the timing could be important, but it's not the only thing. So you'll want to talk to an attorney or an accredited rep about your entire situation, because it also matters, how much documentation do you have? How strong is the case? How long were you guys together before getting married? Was it a short courtship or a longer one? Are there previous marriages? How recently did those end? So there's a few things to consider. Timing is important, but there's not a minimum or maximum time period that you have to wait necessarily to file your green card case. And then another question is, I lost my green card. What can I do? Help. So you have a couple of options. You can file Form I-90, which is typically used to renew a green card, but it can also be used to replace a lost green card. You may have to pay fees if you lost your green card, you definitely have to pay fees. But if you never received your green card, or there was like a fault of USCIS, you may not have to pay that fee. In some situations, in true emergencies or like urgent humanitarian reasons, you can also request an appointment with a local USCIS field office and obtain what's called an added stamp or an I-551 stamp in your passport. this would act as your green card for purposes of travel and work authorization, typically for 6 months. You have to present some proof of your status to get that card, but this can be really helpful if you need to travel urgently or show your employer proof that you of your status. So those are the two options. Okay, as a reminder, send your questions, type them in the comments. Okay. Why is it that if you're on an H-2B working visa for 3 years, you cannot leave America? And if so, it's void. I'm actually not that familiar. I don't really work on H-2Bs, so I'm not sure if there's like a nuance here that I'm missing. But I wonder if you mean if you have an H-1B, which is valid for 3 years, whether you can leave or not. So, I'm wondering if the issue here is, there's a difference between an H-1B petition and your I-94, which controls your ability to stay in the United States. And then there's the visa in your passport. So the visa is different because it's your ticket into the country, but it does not control how long you can actually stay in the country. You have to look at your I-94 for that. So I wonder if you received an approved H-1B and you're looking to leave, that doesn't mean you have to void your petition, but you may need to obtain an actual visa stamp in your home country if you don't have one. Okay. Another question is, my husband was married to a US citizen. They had 2 daughters born in the United States, but they returned to Ireland and got divorced. So he has no need to renew his green card, but now he is considering returning. Okay. I guess the first issue that comes to mind is whether your husband obtained a conditional green card, which was only valid for 2 years, or a permanent 10-year green card. If it was a conditional green card, I assume that they didn't remove those conditions, so that green card may be expired and that status may be invalid. But if they got a 10-year green card, typically you have to remain in the United States for majority of the year in order to maintain your status. And trips longer than 6 months can compromise that your permanent residence. However, you may not really know for sure until he tries to re-enter. So you could consider, returning and presenting that green card, or applying for a re-entry permit if if your husband's permanent residence was already abandoned. I guess this also kind of depends on whether he's traveled in the meantime. So I'd be curious to chat with this family and see and ask more details, because it could be the case that he's already abandoned that green card, and in that case would need to seek some other type of visa, potentially a visitor visa or a new spousal visa. It just kind of depends on the status of that initial green card. Is it safe to travel outside the country while H-4 EAD is pending? I would advise against that. USCIS can consider you to have abandoned that application if you leave while it's still pending. This is a little bit of a gray area, but I tend to advise to just wait while applications are pending with the USCIS. I'm also wondering if this EAD application is a renewal or an initial, so I just want to chat about that more. Okay, I think this is a follow-up to the previous question. I was on H-2B visa and had to come home for family purposes, but couldn't return on that visa again. So again, I'll say I'm not, H-2Bs are not my area of expertise, so there could be something here that I'm missing, but I'd be curious what that refusal notice said, or if an officer told you something specific. But I am happy to refer you to another attorney who does work on H-2Bs. It's just not that's not my specialty, so I don't want to misspeak. Can you change your status from J1 or H-2B to a green card? And how often are those approved? So J1s are unique in that some people receive a J1 that has strings attached. So it can have a notation on it that says that the person is subject to a 2-year home residency requirement. So in that case, the person cannot apply for a green card unless they waive that condition or they go home for 2 years. And whether or not they can waive the condition depends on the country that they're from and the type of J1 they got. So that's also it depends. Theoretically, someone, though, if we were to resolve that issue, could go from J1 or H-2B to a green card. It kind of depends on the basis for that green card. Is it family related? Is it employment related? Because that will also kind of change requirements and considerations. Is it advisable not to apply for B visa for ESTA eligible applicants? Um, it kind of depends because I both of them have, similarities to like their travel purpose, but of course ESTA is reserved for certain countries. Now, I wonder if the issue is ESTA was denied and now you're looking to a B. In general, this is tricky because once there's been an ESTA denial or any type of visa denial, it can always make getting a new tourist visa or temporary visa a challenge. We've seen this, but I've also seen people successfully obtain a B when their ESTA was revoked. But it kind of depends on the reason why the ESTA was denied in the first place. Okay. First time H4 EAD application. Okay, so that's a follow-up to a previous question. I would not travel while that's pending, to be absolutely safe. Otherwise, in some cases, they can consider that you've abandoned that work permit, and so I would advise against travel. Okay. I think there was a part 2 to that J1 to green card question. How often does that get approved? That also depends on, the person's eligibility, and that's super case specific. So if they have other grounds, like criminal history or health reasons or immigration violations, those all matter in that question. So it will depend on that person's specific situation. I think I answered everything that I see so far, but feel free to add any others. While I'm waiting for any other questions to roll in, I just wanted to um, let you know that we have a few more events coming up from our team. So on April 17th, We will be putting on a webinar about O visas for influencers and content creators. This is super exciting and such a cool area of the law. And then on April 24th, there will be a webinar on the EB1A and national interest waiver. That will be presented by my colleague Natalia, and that will be in Russian. So cool. So save the date for that. And then May 5th is our next First Friday. So that will be with someone else from our team. Okay, I think that's all the questions that I see. Thank you so much for joining. As always, we're here to answer any questions that you might have. You can always reach out to us to schedule a consultation, or you can always join us for our next First Friday. So thank you guys so much. We'll talk to you soon.